After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her.
Sounds like to me he's intending on getting the upper hand.
Part of my problem is it doesn't seem that he can de-escalate. This fixation that he has on this infidelity, and quite frankly, if he's playing games, he's playing with the wrong judge to play those games.
Today we're in Judge Simpson's court, and we've got an entitled brat who thinks the entire justice system is some kind of customer service desk that he can negotiate with. He's breaking a no-contact order like it's a gym membership cancellation, just ignoring it and hoping for the best. The way he's trying to manipulate the judge and twist the story is honestly painful to watch, because you can see he truly believes he's smart enough to outplay the court. Spoiler, he's not. Judges don't play guessing games, and I didn't know has never once worked in a court order in the history of Earth. Today, he's about to learn that when you violate a no-contact order, the consequences come faster than his excuses. So the real question is, will Judge Simpson give him another chance, or is this the day he finally gets smacked by reality? Let's go ahead and dive in.
Your Honor.
And good afternoon again, Your Honor. Miles Drew on behalf of Mr. Busick, who's approaching my right, and can you please state your name for the record?
Ryan Michael Busick. All right, thank you. Go ahead. This is your motion.
Thank you, Your Honor. At this time, people are going to be requesting our original request of a $50,000 cash surety bond. In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning to people. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw broken drywall, the door was off the frame, the lock, the deadbolt was still in the locked position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then proceeded to chase her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, you'll see that it was raining, and they were both covered in rain and I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the two calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation of accusing her of cheating and infidelity on the jail calls. And then the next day, when he's arraigned, after he's arraigned, he calls her again, violating his bond. And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim, and it's very concerning to people given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request, and believe that a personal recognizance bond was an abuse of discretion, Your Honor.
Ms. Rhodes.
And Your Honor, we would admit that there was a call that occurred on the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean iChat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who's in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have two children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges, And I have expressed not only to Mr. Busick, but to the family, the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness.
This man is an absolute psychopath. It's insane. I genuinely cannot imagine what this poor woman went through when this deranged man broke through her locked door and started interrogating her like he was starring in a low-budget CIA thriller. What has to be going through someone's mind to think that's a normal, acceptable response to anything? It's not love, it's not passion, it's obsession mixed with delusion, and it's terrifying. Every chance he can get, he's trying to reach out to her like she's an appointment he refuses to cancel. You'd think after spending a night in jail, he might sit there, stare at the ceiling, and realize, maybe I'm the problem. But nope, this man walked into jail, checked into his cell, and immediately started planning his next move. He didn't even wait a full day before calling her from jail like it was some twisted follow-up appointment. You can hear the judge's voice get stiffer and stiffer with each detail because this isn't a misunderstanding, it's a pattern. And when behavior becomes a pattern, judges start seeing someone as a threat, not just a defendant. The worst part is, he genuinely believes he's the victim, which is the most dangerous mindset someone like this can have. I'm honestly interested to hear what the defense thinks they're going to say because so far, everything coming out of their mouth sounds desperate, weak, and painfully embarrassing. He is a danger to this woman and frankly, a hazard to society, and everyone in the courtroom knows it.
As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work, and even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he is the provider for these children, and they get their health insurance through his job, and that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail. So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record, and I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for any reason.
Yet you have understood about that, counsel?
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to have made those calls. We would be asking for a $25,000, 10% with the tether.
But he's still, from the allegations, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. After creating, some damage, or allegedly creating some damage to the premises, and things not going well because now you're in custody, you're told by the magistrate not to have contact, and what does he do? He has contact about the same thing that the allegations are about.
Right. I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are concerning. We can test them as it relates to the case.
Tell me how I can even be sure that he's going to follow this court's conditions.
Well, I think you have his family sitting right here in the courtroom, that they're accountable, good members of our society that are going to be looking out and holding him accountable. They have, financial interests involved in this case as well. They are living with Ryan. He has no prior record, which I think speaks to the fact that they raised him pretty well up to this trying point here. And I think that the tether, was put in place after these phone calls, and there's been no issues with the exclusion zone. So I think in that respect, the tether is working, Judge. And I think you have members of the community that will be looking out to assure that your court order is followed by Mr. Busick. And I think this is a real wake-up call for him, quite frankly. family. This isn't a situation he's used to being into, given his clean criminal record. And I think he's standing up a little bit straighter now after this and understands just how much is on the line after having a stern talking with counsel both last night and prior to court today about the severity of the situation that he's in here, Judge.
In the 14B case, isn't there a no contact?
There is a no contact order in place.
So what's he doing there? That's the part that's troublesome to me. He has a case in which he's the alleged victim, right, counsel?
Correct.
He knows there's a no contact provision, right?
Yes. Well, the no contact provision would run to the defendant in that case, which is the complaining witness in this case.
How it works. That's not my point. My point is, why is him knowing that? Why is he at her residence?
Well, Your Honor, I would say that I think, these no contact orders, I mean, he shouldn't have been seeing her, but this is a 10-year relationship that goes back to when they were 16 years old. They have children in common. While I certainly would have liked if this was handled.
So that's all fine and dandy. But he knows she's not supposed to have contact, right?
Well, he believed the condition was dropped. But I mean, I would agree that he should not be having contact with her.
Where would he get the idea that it was dropped?
I'm not sure, Your Honor.
What is so confusing about a no contact order? It literally could not be more straightforward. Do not contact the person. That's it. There's no algebra, there's no fine print, you don't need a dictionary. Yet here he is, still trying to convince the judge that he didn't understand or thought maybe it was optional, like a store coupon. Is he brain dead, or is he trying to play dumb because he knows the truth won't help him? And then the defense actually tries to flip the victim into the aggressor. Absolutely pathetic. They bring up irrelevant past drama as if that somehow magically excuses kicking down a door and stalking someone. Sure, he has no major priors, but guess what? None of that matters when you commit a violent act and then immediately break a court order. You don't get a free pass just because your criminal record used to be clean. Judges care about patterns, safety, and respect for court authority, and this man has failed on all three. And then his excuse keeps changing. First he didn't understand, and then suddenly he thought the order was dropped. Well, which one is it? You can't accidentally violate a court order and also claim you thought it magically disappeared. Pick a lie and stick with it.
I don't believe that for a minute. I mean, he knows she's not supposed to. I mean, I'll tell you what it sounds like to me. Sounds like to me he's intending on getting the upper hand. So he goes over there and he can basically, in essence, force her to give whatever answers he wants, because the one thing at least he knows or thinks is that if he calls the police, she's in violation, I'm not.
No, I don't think that that's the situation going on. I mean, when the police officers did bring up the no contact order on the scene, he said that he had thought it had been dropped. I mean, I think he's simply concerned about, these beliefs of infidelity, Your Honor. It's an improper way of going about it without doubt. But given that he has no record, he hasn't had any trying situations, he's only 26 years old, any trying situations like this in his life, I would view this as kind of a one-off situation, that now that he has the accountability structure in place with his family, being aware of what's going on, being in the courtroom here supporting him, that this type of behavior would not continue, and I expect him to comply with all court orders going forward, Judge.
Anything else from people?
Nothing, I mean, I just have concerns given what the court stated with the no contact order in the 14B case, and given that the victim in her interview with police at the scene states that they're separating, so I don't know why he would go to her residence to accuse her of this break-in and assault her. I just don't understand. But nothing else from the people as far as this goes, Your Honor.
Right, and I think you know this, counsel. What I really should do is I should revoke his bond. He doesn't make it a day before he's violating the bond condition.
I understand the court's concern.
It's not. What is troublesome for me is that he violates the bond condition. And when you look at the transcript of what he's talking about in the very first part, it's just a continuation of what got him there in the first place.
And I think sorry.
Go ahead.
I was going to say, I think the stern talking to that I've had with both him and his family about the, concerning nature of these allegations, the phone call transcript, I think that he's been very receptive to my feedback, and I don't see that this being an issue going forward. This was, within a day of the incident, his emotions were still very, high in charge. It's obviously no excuse for doing what he did, but given that...
Counsel, that's part of my problem. Part of my problem is it doesn't seem that he can de-escalate. because he gets involved in this thing, gets arrested. This fixation that he has on this infidelity, even after he's arraigned, even after he's warned, admonished what he can do, what he can't do. Within hours of that, he can't step back. He just can't.
I understand the court's concern. I would say, while I would not have advised him to send any of those emails to the court, the fact that he's reaching out to the court, not to her, is some indication of change from the, Friday before.
No, it's really not.
He's not reaching out to her. I certainly would not have advised him to send those emails, and I have instructed him going forward not to do anything like that and to run anything he's doing with these cases through counsel going forward.
Listen.
Even the emails are concerning. In the emails, he's trying to get her in trouble, trying to use this as leverage against her in the other case. He just can't stop. Even if it's not contacting her, it's this continued obsessive feelings towards this victim.
I'm certainly not pleased with the emails being sent, but I would note that it does appear that there are potentially bond violations on the other case. That's not a concern for this court here, but it's not like he's making up and frivolly.
Why is it even his?
Your Honor, I have no good explanation for that.
Tell me what your client's purpose in sending those to the court. What was the purpose in sending those to the court?
Wanted to alert them of the bond violations that have been alerted of in his case, Your Honor. It's not anything that he's proud of, but, he was going to change his actions going forward.
It's not my court. He knows what court it's in. Why is he sending it here?
I think people commonly get confused about the 14th.
Counsel, look at the very first email. He's not confused, because he's real clear about what he thinks is happening with her defaming him.
Oh, I meant the confusion about 14A or 14B, Judge. I understand.
But I'm saying, why did he send it here? I'm not the judge. He knows it. He's not confused about what court it is at all.
But I think he did believe he was reporting it to the court of record, albeit mistakenly, Judge.
Is he going to tell me that if I put him under oath that he thinks he's sending it to the right place?
Yes, he was.
There is no way. Why is it coming right now? When were those videos taken? When were those videos taken?
About a month ago. And that was...
She's got a winter sweater on in like May? Really? So if you had them for a month and you think you're contacting that court, what took you so long?
There's no excuse for the timing.
No, what took him so long? This is his story. He's trying to convince me that he can behave.
Would you like me to speak?
Go ahead.
So I didn't want to contact the court because, yes, we were working on things, and I spoke in front of you, and I believe that the no contact was dropped so we could start to work on things. I came in front of you and said that during her case one day.
Your Honor, I would note that it was charged as a felony case, and I know you typically sit on the PCC docket, so you may have been a judge that appeared on that case at some point. My understanding is that currently it is just the misdemeanor domestic violence charge that is still pending against the complaining witness, but I do believe it was a felony case where it's possible you would have been a judge that sat on that docket.
And, Your Honor,
You can literally see the judge give up on the defense mid-speech. He's not interrupting, he's not asking questions, he's just staring into space like he's counting the ceiling tiles until he can bring the hammer down. The moment he leaned back in his chair with his head tilted upward, the entire courtroom knew it was over. That's the body language of a judge who's heard enough nonsense to last a lifetime. He doesn't buy a single word of their story, not the miscommunication, and not the misunderstanding, and definitely not the sudden shock that breaking a court order has consequences. The lawyer keeps repeating that he gave the defendant a stern talking to like this is kindergarten and the kid got caught stealing crayons. Grown adults do not need stern talking tos. They need accountability. This man should know the difference between right and wrong by now, but he clearly doesn't care. And that's why the judge isn't even considering leniency, because if he walks out of court today, the victim is in danger again tomorrow. The judge is done playing babysitter. The legal system is not here to negotiate with grown toddlers.
if the court does remember, you were on that case for PCC's vote. The people had declined to address the no contact and change it, given concerns of the case.
You were looking to report these month-old alleged bond violations. Why did the court need to know that now she's defaming you?
I just said there's no excuse for sending it.
There's no excuse for the slanderment.
What?
No excuse for the slander.
Yeah, but how is that a bond violation?
I believe there was an understanding from Mr. Busick that there was some kind of no alcohol or no drug provision as part of her pretrial release order. I believe that's what he understood. Whether that is or is not the case, I'm not sure, Judge.
But then it says, and is now causing defamation against me. Why is that important to the other court?
It's not.
Yeah, it's only important to this court.
Correct.
And this bond hearing.
And I did believe that it was still here. I didn't know it was at 14B.
How come you didn't go through your attorney to send this?
I was not retained at that time, Your Honor.
No, he had a PD at the time. Why didn't you go through her?
I did try to call her that morning after speaking to the prosecutors, I believe. But I was at work and I missed her call back.
When, yesterday?
Yesterday, yes.
So you decided that you just send it?
Well, yes, so I did. I called the courthouse on my break and I said, you know, where do I contact for breaking bond? I should not have, Your Honor.
Why was it so important for you to report her breaking bond? Let's assume it to be true. Why was that so important? Right now.
Well, it was
Careful how you answer me.
correct. It
Because, no, listen. Why was it so important to do that? You had just received an emergency bond motion to change your bond. You then start sending stuff. Why is it so important to now report what you say is a month old? I think they're older than that. The month-old video. Why is it so important to do that this week?
I wasn't thinking, Your Honor.
Why was it so important? I don't care. What was your thinking? Whether clear or not, what was your thinking?
I mean, I really wasn't thinking. I really wasn't thinking clearly. I'm not too sure.
I suspect the court could hear Mr. Busick there. I mean, he has no justification. He clearly wasn't thinking straight. I mean, I think he was feeling the pressure of the bond violations in this case, was aware that, or thought he was aware that she may be violating her bond. There's no good justification. There's no answer that we're going to provide you, Judge, that ultimately satisfies you.
So what makes me not believe that as he feels the pressure of this case, that he doesn't lash out and do something?
Well, I think his children...
Why would I believe that? He had counsel at the time.
I don't think he had the same trust relationship with that counsel that he has now. And I think knowing how much his children's health care is on the line because of this, because his job is on the line.
It's all on the line. It was
absolutely
on the line after he was arrested. It was on the line when he made that call. It was on the line when he starts sending these emails. It's always been on the line. I don't know why he can't recognize that. And that leads me to believe that no matter what I tell him, he can't do it. If he doesn't understand that from the very beginning, what's at stake. And I do believe that he went over to that unit. Now, he went over there to get her in trouble, just like these emails. That's what he's doing.
No, I don't think that the facts when the case is litigated will show that that was his intention at all, Your Honor. I understand the court having concerns, but I think not only, my talking with him, but now this, bond violation hearing in front of his parents, I think he's going to be standing much straighter. I think he understands it. I wish he was a quicker learner.
It shouldn't take his parents to make him stand up and do right.
And it doesn't, Your Honor. I think that he'll prove that going forward on bond. And I think
quite
to the extent that he needs help, he can get better help and services outside of jail than he could inside.
Frankly, they shouldn't have to be here.
Right, and he agrees.
I mean, even if the prosecutor objected, they shouldn't have to be here.
Right. And Mr. Busick agrees. He's embarrassed and shamed by what he is putting, not only himself, but his family through in this. He's not proud to be here today, Your Honor.
Well, I understand what the people's request, I understand what the defendant's request is. I don't think since he's gotten out until he's called to the carpet, this defendant really does conduct himself appropriately. I don't think that has anything to do with his parents or his family or his upbringing or anything along those lines. He just can't do it. And then start sending, he's got an attorney and he's just sending these emails to the court, accusing her of things. He's in her proximity. He doesn't need to be around her at all. He doesn't need to be contacted. He just continued, and that's the part that is striking to me, is the allegations in this case was that he's arguing about some infidelity. He gets arrested, he goes to jail, he gets arraigned, and at no point after that whole process, after they told him, don't contact her, don't talk to her, he's got attorneys, he's all of those things. What does he do? He calls her again to berate on her. And it's very clear from her responses in the transcript. She doesn't want to talk to him about that.
Now the defendant is trying to flip the situation by accusing the victim of breaking her bond. Absolutely hilarious. The judge, the attorneys, the courtroom spectators, everyone knows exactly what he's doing. He's trying to create chaos and confusion so his own actions get buried underneath fake accusations. The best part is when he tries to play dumb and pretend he didn't realize what he was doing, and then immediately gets caught in his own lie. The judge saw straight through it. His confusion wasn't confusion, it was strategy, and a terrible one. The court wants honesty, and this guy gives nothing but manipulation, excuses, and emotional tantrums. Every time he opens his mouth, he makes himself look more dangerous and less trustworthy. You can practically see the jail bars forming behind him as the judge listens. It's obvious where this case is headed, and it's definitely not home sweet home. His future is looking like concrete walls, metal doors, and a very silent phone.
And he just keeps on. And then, if that isn't enough, he then says, oh, okay, well, this is my paraphrase, well, if you won't answer me, I'm going to try to get you in trouble and get you locked up, so I'm going to send this a month after. He's just playing games. And quite frankly, if he's playing games, he's playing with the wrong judge to play those games. Defendant's bond is going to be set, and the court is going to find on two bases. One, his violation after the bond terms were set, the court can review his bond. But I also think, given the way this defendant is exemplified by everything, that it was indeed an abuse of discretion to set his bond at a personal or cognizant bond in this case. Defendant's bond will be reset. The conditions still apply. His bond will be reset at $50,000 cash surety.
Would you consider a 10% provision, Judge?
Cash surety. You can raise it again if you want to on the 12th, but right now he's going.
Fair enough. I hope you and your staff have a great day.
You do the same, sir.
Good morning, or good afternoon, Your Honor. Miles Drew on behalf of Mr. Ryan Busick, P number 84554. Mr. Busick, could you please state your name for the record?
Ryan Michael Busick.
This is a date and time set for PCC.
And Your Honor, at this time, I've made a request for the video and digital discovery in this that has not been tendered to me yet, so we'd be requesting an adjournment of the PCC.
All right. There would need to be a green sheet that would need, you may not be aware of that. We'll get you a green sheet to fill that out.
Sure thing, Your Honor.
All right.
Your Honor, just for the record, there was also, the media discovery we have is in the discovery packet and should be sent over to counsel. And then I also, I called yesterday, have not received that yet, but it should be in route soon.
All right.
And Your Honor, we would like to address bond when the court is ready.
You want the 26th or the 3rd, counsel?
Give me just a moment to check my calendar, Judge. The 26th would be fine if I could be accommodated, say at like 10 a.m. or later.
Well,
I haven't.
You'll likely be in more toward the afternoon, but I will set it at 9. And then we'll place you into a block. We noted what you've indicated, but
Very good. Yeah, I do have a
if he's
hearing.
in custody, you'll be in the 9 o'clock block, I will tell you.
Okay, I may just be tardy for court then that day. I'll be coming directly from.
All right. Yes, that's about.
As to bond, while I know the court heard me 2 days ago, I would note that, due to Mr. Busick having no record, these last 2 nights in jail have left an incredibly strong impression on him. Not only the seriousness of this case, but the importance of following all conditions of any bond or any court order going forward. He would like to get back out working so he can save his health care for his children and for himself. He would like to pursue a mental health evaluation. I have talked to clinical therapists, one named Virginia Dawson, who works closely with many courts in Oakland and Wayne County, and she's worked with my office for years. She has experience at the 48th and 16th District Court. I've confirmed that she has appointments that would be available to him every single day next week, depending on his schedule. So we would accordingly renew our request for a cash bond that Mr. Busick can afford of $25,000, 10%, Your Honor, with the tether, obviously.
Response from the people.
Your Honor, I believe the court knows where the people stand on bond. At this point, I'm going to object given the fact of the bond violation originally and then the facts of this case. I believe the bond that is currently set at this moment is appropriate for this case, given all that was stated previously on the emergency bond motion as well as the bond violations that came up as part of it.
And the court would incorporate its findings a couple of days ago addressing the emergency bond. The emergency bond filed on behalf of the people, and particularly noting that after the point of arraignment, the defendant's conduct, I don't think, would lead the court to believe that this defendant would be able to follow all of the conditions as set without some cash component or significant cash component in place to try to assure his compliance. And also the court does believe because of those actions, the defendant does pose a risk or threat to the community. And so therefore the court will deny the defendant's motion to reduce the bond in this case once again.
Would you consider a 10% provision on the current bond, Your Honor?
You asked me that yesterday 3 times, and so the answer is the same now.
Fair enough, Your Honor.
All right.
I hope you and your staff have a good afternoon. Thank you for allowing me to make a record as always.
Thank you.
Thank you.
A straight $50,000 cash surety, no more PR bonds, no more promises, no more games. And honestly, that's exactly how it should be when you're a danger to the public and a threat to the victim. The judge is tired, the attorneys are tired, and honestly the viewers are tired, because this man still thinks he's the smartest person in the room. He tried manipulating the system like it was a video game, and instead ended up leveling himself into jail. Hopefully this is finally the moment where he figures out how to live a life without stalking, lying, and terrorizing people, and maybe he'll learn that no contact order means exactly what it says. The funniest part is, he came back just a few days later trying to get his bond reduced, like 3 days in jail changed his entire personality. The judge denied him so fast, the courtroom air probably shifted. Time to sit in a cell, stare at the wall, and rethink his entire existence. Actions speak louder than excuses, and at this point, his actions are screaming. Thank you so much for watching, don't forget to like and subscribe, and I'll catch you in the next one.
If there's one lesson to take away from this hearing, it's that the courtroom isn't just judging what happened on the day of the alleged offense, it's judging what happens after. That's where this defendant made his biggest mistake. Notice what kept frustrating the judge. It wasn't just the allegations. It was the pattern. Every opportunity the defendant had to show restraint, he instead doubled down. The phone call, the emails, the continued obsession with proving infidelity. Each decision reinforced the court's concern that he simply couldn't respect boundaries or follow clear court orders. From a legal standpoint, bond isn't a reward for having no criminal history. It's about one question: can the court trust you to obey its conditions while your case is pending? And based on everything the judge heard, that trust had been broken almost immediately. I also thought the judge handled this exactly the way experienced judges often do. He wasn't interested in dramatic excuses or emotional explanations. He kept bringing the discussion back to the same issue: behavior. Not promises. Not intentions. Actions. Whether these allegations are ultimately proven at trial is a separate question for another day. But bond hearings are about public safety, compliance with court orders, and risk. On those issues, the judge believed the defendant had already answered the court's questions with his own conduct. That's what made the $50,000 cash bond feel less like punishment and more like a consequence of repeated choices. Let me know your thoughts below. Did the judge strike the right balance between protecting the community and preserving the defendant's rights? I'd love to hear your perspective, and I'll see you in the next case.